Definition of criminal law. Criminal law is a branch of municipal law which defines crimes, treats of their nature, and provides further punishment. In the Philippines, there exist no crimes, such as those known in the United States and England as common law crimes. Our country adheres to the principle of nullium crimen nulla pena sine lege, that is, there is no crime where there is no law punishing it. The maxim of nullum crimen nulla pena sine lege is an indispensable corollary to a regime of liberty enshrined in our Constitution. It is of this essence that while antisocial acts should be penalized, there must be a clear definition of the punishable offense as well as the penalty that may be imposed. There are two theories in criminal law, to wit, classical theory and positivist theory. Classical theory. Under the classical theory on which our penal code is mainly based, the basis of criminal liability is human free will. Man is essentially a moral creature with an absolute free will to choose between good and evil. When he commits a felonious or criminal act, the act is presumed to have been done voluntarily. Example, with freedom, intelligence, and intent. Man, therefore, should be adjudged or held accountable for wrongful acts so long as free will appears unimpaired. Positivist theory. The positivist theory states that the basis of criminal liability is the sum total of the social and economic phenomena to which the offense is expressed. The purpose of penalties is to secure justice. The penalties imposed must not only be retributive, but must also be reformative, to give the convict an opportunity to live a new life and rejoin society as a productive and civic spirited member of the community. The revised penal code is based on the classical school of thought. However, there are some aspects of the code which are based on positivist theory. Mala inse and mala prohibita. Mala inse and mala prohibita are distinguished as follows. A mala inse are inherently wrong or immoral, while mala prohibita are not inherently wrong. They're only wrong because they are prohibited by law. In mala inse, good faith or lack of criminal intent is a defense, while in mala prohibita, good faith is not a defense. Modifying circumstances can be appreciated in mala inse. These circumstances will not be appreciated in mala prohibita unless the special law that punishes them adopts the technical nomenclature of the penalties of the revised penal code. Mala inse are punishable under the revised penal code or special laws where the acts punishable therein are wrong in nature. Mala prohibita are punishable under special laws. A common misconception is that all mala inse crimes are found in the revised penal code, while all mala prohibita crimes are provided by special penal laws. In reality, however, there may be mala inse in crimes under special laws, such as plunder under RA 7080. Similarly, there may be mala prohibita crimes defined in the revised penal code, such as technical malversation. The better approach to distinguish between mala inse and mala prohibita crimes is a determination of the inherent immorality or vileness of the penalized act. If the punishable act or omission is immoral in itself, then it is a crime, mala inse. On the contrary, if it's not immoral in itself, but there is a statute prohibiting its commission by reasons of public policy, then it is mala prohibita. Dungo versus People, GR number 209464. Thus, election offense is malum prohibitum, although it is punishable under special law. Construction of penal laws. It is a basic rule in statutory construction of criminal laws that in case of doubt, it should be resolved in favor of the accused. Number 1. Pro reo. In dubio pro reo means when in doubt for the accused. Intimately related to the in dubio pro reo principle is the rule of lenity. Lenity. The rule applies when the court is faced with two possible interpretations of a penal statute, one that is prejudicial to the accused and another that is favorable to him. The rule calls for the adoption of an interpretation which is more lenient to the accused. Number 2. Spanish text. The revised penal code is patterned after the Spanish penal code. The revised penal code was written in Spanish when it was submitted to the legislature for approval. The English text of the revised penal code is just a translation of the Spanish text. What was approved by the Philippine legislature is the Spanish text of the revised penal code. Thus, in interpreting the provisions of the revised penal code, the Spanish text of the said code is controlling, as this was the text approved by the legislature. Furthermore, Spanish jurisprudence may also aid the court in interpreting the provisions of the revised penal code. People versus Nukum, GR number L482, February 25, 1947. Number 3. Title and body of penal provision. The titles of the article of the revised penal code were not intended by the legislature to be used as anything more than catchwords, conveniently suggesting in a general way the subject matter of each article, being nothing more than a convenient index to the context of the articles of the code. They cannot in any event have the effects of modifying the words of the text. Scope of application and characteristics of criminal law. There are three characteristics of criminal law, or cardinal features of principles of criminal law. Number 1, generality. Number 2, territoriality. And 3, prospectivity. Under Article 14 of the Civil Code, penal law shall be obligatory upon all who live or sojourn in the Philippine territory. This is the Generality Principle. Letter A. Foreigner. The foreign characteristic of an offender does not exclude him from operation of penal laws. The argument of accused that he did not incur criminal liability because both he and the victim were Indonesians is not tenable. An alien is not immune from criminal prosecution for violation of the trademark law committed in the Philippines. Trademark law is obligatory to a foreigner who is living or sojourning in the Philippines. Lifted from 2011 bar exam. Military offender. Penal laws are obligatory to military men residing or sojourning in the Philippines. The courts have jurisdiction to try military offenders charged with violation of the penal laws. Its jurisdiction is unaffected by the military or other special characters of the accused. However, service-connected crimes shall be tried by the court-martial as mandated by RA 7055. Territoriality and generality. The concept of generality is different from territoriality. The applicability of territoriality principle or generality principle will depend on the issue raised by the accused in invoking criminal immunity. If the accused invokes immunity because of the unique characteristic of his person, example, he is a foreigner, military, hermit, primitive, ambassador, legislator, president, the applicable principle is generality. If the accused invokes immunity to the unique characteristic of the place where the crime was committed, example, the place of commission is a foreign vessel, embassy, or high sea, or others, the applicable principle is territoriality. Exceptions. Under Article 14 of the Civil Code, the generality principle is subject to principles of public international law and treaty stipulation. However, law of preferential application and case law are also recognized exceptions to the principle of generality. Principles of international law. Penal laws are not obligatory to persons entitled to criminal immunity because of the principles of international law. Under the old rule, a consul was not exempt from criminal prosecution for violation of the laws of the country where he resided. Under the present rule, consular officers are immune from criminal prosecution of acts performed in the exercise of function. Immunity does not cover slander or reckless imprudence resulting in homicide, lifted from 1975 bar exam, for not being function related. A Chinese diplomat who killed another Chinese diplomat in Cebu is immune from criminal prosecution. Unlike consular officers, diplomatic agents are vested with blanket diplomatic immunity from civil and criminal suits. Unlike ministers, presidents and ambassadors and chief of mission, a commercial attaché is not a diplomatic agent. Hence, he is not exempt from the generality rule of criminal law, lifted from 2011 bar exam. French diplomat stationed in the Philippines is immune from criminal prosecution for reckless imprudence resulting in homicide, lifted from 2014 bar exam. Charles Givers is immune from criminal prosecution for multiple frustrated and attempted murders, lifted from 2016 bar exams. Laws of preferential application. Article 349 of the Revised Penal Code on bigamy is not obligatory to Muslims married in accordance with the Muslim laws because of PD number 1083, the Code of Muslim Personal Laws. Under PD number 1083, penal laws related to the crime of bigamy shall not apply to a person married under Muslim law, where the requirements set therein are met. PD 1083 is a law of preferential application. However, if the marriage is not solemnized in accordance with Muslim law, the accused cannot claim criminal exemption from liability for bigamy on the basis of his religious belief as a Muslim because of the Generality Principle. PD 1083 is not applicable since the marriage was not made in accordance with the Muslim law. Nolora Jr. versus People GR number 191425. Case law. Penal laws are not obligatory to the President because of the presidential immunity recognized by case law. The President of the Philippines is entitled to immunity from suit subject to the following conditions. Number 1. The immunity has been asserted. 2. During the period of his incumbency and tenure. 3. And the act constituting the crime is committed in the performance of his duties. Presidential immunity will assure the exercise of presidential duties and functions free from any hindrance or distraction, considering that the chief executive is a job that demands undivided attention. During the period of his incumbency and tenure, President Aquino cannot be charged with simple negligence resulting in multiple homicides in connection with the Mama Sapano incident because of his immunity from suit. His decisions concerning the handling of the police operation leading to the tragic event are official acts. It is submitted that a vice president could not invoke immunity from criminal prosecution for plunder and corruption under RA 3019 on the following reasons. Plunder and corruption are not his official conduct as a vice president. Number 2, the job of a vice president, unlike the head of the executive department, does not demand undivided attention. 3, and the implementation of principal penalty of imprisonment for plunder and corruption is not inconsistent with the constitutional provision on non-removal of impeachable officer except through impeachment proceedings, since he can function as vice president while serving sentence prison. However, accessory penalty of disqualification, which involve removal from office, is not implementable since enforcement thereof will offend Section 2 of Article 11 of the Constitution, which mandates that the Vice President may be removed from office only through an impeachment proceeding. The provisions of the revised penal code shall enforce within the Philippine territory. Territorial Principle. Embassy. The ground occupied by U.S. Embassy is not in fact the territory of the USA to which the premises belong to possession or ownership. A person who committed a crime within the premises of an embassy will be prosecuted under the law of the Philippines because of the principle of territoriality. That is Reagan versus Commission on Internal Revenue, GR 26379. According to C.A. Justice Kokia, the modern tendency among writers is toward rejecting the fiction of extraterritoriality of diplomatic premises. In the case of Kent, the British courts held that a crime committed in a foreign embassy is a crime committed in the United Kingdom, and the offender, if not protected by diplomatic immunity, is liable to prosecution in the British courts. However, jurisdiction of the Philippines over the embassy is limited or restricted by the principles of inviolability of diplomatic premises, which is a general accepted principle of international law. A warrant of arrest cannot be served inside the U.S. Embassy without waiver from the U.S. government of its right under the principle of inviolability. Territorial waters. Territorial waters refer to all waters seaward to a line 12 nautical miles distant from the archipelagic baseline over which the Philippines exercises jurisdiction. These waters are located between the national or archipelagic water and the territorial lands of the Philippines and the high sea. Territorial waters do not include national waters, which are within the baseline drawn in accordance with the archipelago doctrine. There are three fundamental rules in international law regarding crimes committed aboard a foreign merchant vessel, not military vessel, if the same is within the 12-mile territorial water of the Philippines, not internal or archipelagic water, or high seas to it. French rule. Under the French rule, flag state principle, crimes committed aboard a foreign merchant vessel within the territorial water of the Philippines are subject to the jurisdiction of the flag state unless their commission affects the peace and security of our country. English rule. Under the English rule, coastal state principle, crimes committed aboard a foreign merchant vessel within the territorial water of the Philippines coastal state are subject to the jurisdiction of the Philippines unless their commission does not affect the peace and security of our country or has no pernicious effect therein. Convention of the Law of the Sea. The flag state of foreign merchant vessel passing through the territorial sea has jurisdiction over crimes committed therein. However, the Philippines coastal state can exercise jurisdiction towards any person or to conduct any investigation in connection with any crime committed on board the ship during its passage in the following cases. Number one, if the consequences of the crime extend to the Philippines. Number two, if the crime is of a kind to disturb the peace of the Philippines or the good order of the territorial sea. 3. If the assistance of the local authorities has been requested by the master of the ship or by a diplomatic agent or consular officer of the flag state, or if such measures are necessary for the suppression of illicit traffic in narcotic drugs or psychotropic substances. Under the old rule, the controlling principle was the English rule. But since the Philippines is a signatory to the Convention of the Law of the Sea, it must be considered in determining jurisdiction over crime committed aboard a foreign ship within the territorial water of the Philippines. Murder is committed on board a foreign merchant vessel a few moments after it left the port of Manila, 2015 bar exam, or in the breakwater of Manila Bay, 2011 bar exam. The vessel is within the territorial waters of the Philippines when the crimes was committed. Murder committed by accused disturbed the peace of the Philippines, hence he could be prosecuted in Manila. Spratly Islands and regime of islands. Spratly Islands are a chain of islands in the South China Sea, the ownership of which is being disputed by the Philippines, Taiwan, Malaysia, Vietnam, Brunei, and China. The People's Republic of China considers the entire Spratly Islands as part of China and claims that it has historical naval presence therein. Thus, the Philippines had no jurisdiction over a crime committed by a Filipino in the disputed Spratly Islands. However, the Philippines has jurisdiction over crime committed in Kalayaan Island, which are the western part of Spratly Islands. Kalayaan Islands became res nullius, nobody's property, when Japan, which had briefly occupied them during World War II, renounced their sovereignty over the island through the Treaty of Peace. Thomas Cloma, who actually discovered the uninhabited islands, ceded his right in favor of the Philippines. The Philippines asserted ownership over Kalayaan Islands by establishing therein the municipality of Kalayaan in 1978. The national and local elections are even regularly held there. The court also has jurisdiction over a crime committed in Kalayaan Islands or Scarborough Shoal regimes of islands because the baseline law, RA 9522, declares that the Philippines exercises sovereignty and jurisdiction over it. Foreign countries. Under the principle of territoriality, the Philippines has jurisdiction over crimes committed inside its territory, except as provided in the treaties and laws as preferential application. Thus, the court has jurisdiction over concubinage involving illicit relationship maintained in the Philippines, but it has no jurisdiction over bigamy involving subsequent marriage contracted in Hong Kong, Singapore, or New York. But a lawyer can be disbarred from contracting a bigamous marriage in a foreign country. Extraterritoriality Principle. Article 2 of the Revised Penal Code provides two principles to it: Territoriality Principle and Extraterritoriality Principle. Both principles are subject to treaties and laws of preferential application. Under the principle of extraterritoriality, the Philippines has jurisdiction over crimes committed outside its territory as provided in Article 2, paragraphs 1 to 5. Flag state rule. Under the flag state rule, the courts has jurisdiction over the hijacking of PAL airplane in an American territory since it is registered in the Philippines. But it has no jurisdiction over a murder committed in a vessel registered in Panama while on high seas, although it is owned by a Filipino. Forgery. Under the protective principle, criminal laws shall be enforced outside the jurisdiction of Philippines against persons who should forge or counterfeit Philippine coin or currency notes, or obligations in securities like treasury bill, or who should introduce or import forged currency, note, or securities and obligations into the Philippines. X, a resident of Hong Kong who counterfeits Philippine money in Hong Kong can be prosecuted in the Philippines, even though the crime is committed outside the territory of the Philippines. X cannot invoke the territoriality principle. Under the extraterritoriality principle, the provisions of the revised penal code shall be enforced outside the jurisdiction of the Philippines against those who should forge or counterfeit Philippine currency note. This is an exemption to the territoriality principle. Even though X is not residing or sojourning in the Philippines, he cannot invoke the generality principle. Under the protective principle, a state has jurisdiction over acts committed abroad by nationals or foreigners which are prejudicial to its national security or vital interests. This is an exemption to the generality principle. 2012 bar. Forgery of US dollar committed inside the territory of the Philippines can be prosecuted in the Philippines because of the principle of territoriality. Forgery of US dollar committed outside the territory of the Philippines cannot be prosecuted in the Philippines because the principle of extraterritoriality is only applicable to forgery of Philippine peso. Function-related crime. Function-related crimes are those committed by public officers under the revised penal code and under special criminal law, such as anti-graft and corruption practices law and plunder law. The functions contemplated by this rule include those which should be performed under the law by the public officers in the foreign service of the Philippine government in a foreign country. Thus, the following can be prosecuted in the Philippines: 1. Falsification of public documents by a consul of the Philippines stationed in a foreign country in connection with his function of issuing visa allowing a foreign applicant to enter the Philippine soil is within the jurisdiction of the Philippines. Number 2. Plunder committed at his place of assignment abroad by a Philippine public officer. Under extraterritoriality rule, the court has jurisdiction over direct bribery and falsification of document committed by a public officer in the Philippine consular premise stationed in America, but not corruption of public officer and falsification of document committed by private individual as principal by inducement. National security. Under the protective principle, the provisions on crimes against national security, such as treason and espionage, shall apply even outside the jurisdiction of the Philippines. Rebellion is not a crime against national security. Hence, the code cannot be given extraterritorial application for rebellion committed outside the territory of the Philippines. Universal crime. Under the universality principle, the court has jurisdiction over piracy committed on high seas for being a universal crime, but it has no jurisdiction over murder qualified by the circumstance of taking advantage of the calamity brought about by piracy on the high seas. The 12-mile territorial water of Sabah, Taiwan, or the Dutch may be considered as high seas. Hence, piracy committed therein can be prosecuted in the Philippines because of the universality principle. There are only three crimes against the laws of nation under the revised penal code, to wit: piracy, qualified piracy, and mutiny. Pirates are in law hostes humani generis. Piracy is a crime not against any particular state but against all mankind. It may be punished in the competent tribunal of any country where the offender may be found or carried into. Jurisdiction over piracy, unlike all other crimes, has no territorial limits. It is a crime against all, so it may be punished by all, nor does it matter that the crime was committed within the territorial waters of a foreign state. The person guilty of a felony who is not a wait. The underlying reasons behind the extraterritoriality rules are as follows. Under the flag state rule, a vessel registered in the Philippines is considered an extension of the Philippines. The protective interest principle involving forgery and crimes against national security seeks to protect the financial stability and existence of the state. 3. The extraterritoriality principle involving function-related crime committed by a public officer is designed to implement the constitutional mandate on public accountability. And 4. The universality principle involving piracy and mutiny protects vessels while traveling on high seas, which is important in world trade and commerce. Special laws. The territoriality principle and extraterritoriality principle in Article 2 of the Revised Penal Code are applicable even if the crime is punishable under special laws. Thus, the principle of extraterritoriality is applicable to piracy under PD 532 or plunder under RA 708. However, Article 2 of the Code is not applicable to trafficking in persons and terrorism because the laws that punish them have specific provision for extraterritorial rule. Trafficking in persons. The state shall exercise jurisdiction over trafficking in person, even if committed outside the Philippines, the crimes being a continuing offense, subject to the following conditions. The trafficking in person has been commenced in the Philippines and other elements have been committed in another country. 2. The suspect or accused is a Filipino citizen. or B is a permanent resident of the Philippines or has committed the act against a citizen of the Philippines. A foreign government has not prosecuted or is persecuting a person for trafficking in person except when there is an approval of the Secretary of Justice. Terrorism. The provision of the terrorism law or human security law shall apply to individual persons who, although physically outside the territorial limits of the Philippines, conspire or plot to commit terrorism inside the territorial limits of the Philippines, commit any of the crimes involving terrorism on board a Philippine ship or Philippine airship, commit any of the crimes involving terrorism within any embassy, consulate, or diplomatic premises belonging or occupied by the Philippine government in an official capacity, commit any of the crimes involving terrorism against Philippine citizens or person of Philippine descent, or their citizenship or ethnicity was a factor in the commission of the crime, or commit any of the crimes involving terrorism directly against the Philippine government. Prospectivity. Under the prospectivity principle, criminal law merely punishes crimes committed on or after its effectivity. Under Article 21 of the Revised Penal Code, no felony shall be punishable by any penalty not prescribed by law prior to its commission. The prospective character of criminal laws presupposes that they are not favorable to the accused. If a criminal law is favorable to the accused, it must be given a retroactive effect. Criminalization is not favorable to the accused. The law should be given a prospective effect. Hence, prosecuting a person for a crime committed prior to the passage of the law, punishing it is not allowed. Prior to RA number 10951, the highest penalty prescribed by Article 217 of the Revised Penal Code for malversation is reclusion temporal in its maximum period to reclusion perpetua. However, RA 10951 amended Article 217 of the Code, which now prescribes reclusion perpetua for malversation where the amount involved is more than 8.8 million. In this regard, RA 10951 shall be given a prospective effect since prescribing reclusion perpetua for malversation is not favorable to the accused. Applying Article 21 of the Code, no felony shall be punished by a penalty not prescribed by law prior to its commission. Retroactive effect. As a general rule, penal laws shall have prospective application, lest they acquire the character of an ex post facto law. However, there are exemptions of the prospectivity rule. Laws shall be given retroactive effect if the law is favorable to the accused, who is not a habitual delinquent. If the law decriminalizes an act, or if the law expressly provides retroactivity. Favorable law and non-habitual delinquency. Penal laws shall have retroactive effect insofar as they favor the person guilty of a felony who is not a habitual delinquent. In sum, there are two requisites to apply the law retroactively to it. The law is favorable to the accused, and the accused is not a habitual delinquent. The retroactive effect will benefit a convict, although he is already serving his sentence. Reclusion perpetua, which has duration of 40 years or 30 years if the accused had undergone preventive imprisonment. Penal Code as amended by RA 10592 is a lighter penalty than life imprisonment, which has no duration. Hence, a mandatory law which prescribes reclusion perpetua instead of life imprisonment for a crime punishable under it is favorable to the accused, and this it shall be given a retroactive effect. Found in People v. Morilla, GR number 189833, February 2014. RA 9346 prohibits the imposition of death penalty, prescribes reclusion perpetua in lieu of death penalty or life imprisonment if the special law does not use the nomenclature of penalties under the revised penal code, and declares that a person sentenced to reclusion perpetua as a prescribed or reduced penalty is ineligible for parole. This law has a retroactive effect. Penal laws which are favorable to accused are given retroactive effect. But even if the law is favorable to the accused, it shall be given prospective effect if he is a habitual delinquent or if the law expressly provides prospectivity. Decriminalization. Decriminalization. RA 10158. Decriminalization. Vagrancy. Vagrancy under Article 202 of the Revised Penal Code. Since vagrants are victims of poverty, should be protected rather than punished. RA 10655 decriminalizes premature marriage under Article 351 of the Code for being discriminatory and antiquated. RA numbers 10158, 10655 shall be given a retroactive effect. If a law repeals a previous law and decriminalizes the act punished by the latter, the court loses jurisdiction to punish persons charged with the decriminalized act. People versus Sindong, GR number L335. Hence, criminal cases for a decriminalized act should be dismissed without precondition. In sum, the case will be dismissed regardless of whether or not the accused is a habitual delinquent. Article 22 of the Revised Penal Code, which disallows retroactive application of the law in favor of a habitual delinquent, is not applicable. The applicable principle is nullum crimen nulla pena sine lege, since the intention of the new law is to decriminalize an act punishable by a repealed law. The accused should be acquitted or released if already convicted, even though he is a habitual delinquent. The accused who is charged with vagrancy is a habitual delinquent, RA 10518, which decriminalizes vagrancy shall be given a retroactive effect. The case will be dismissed with precondition. In other words, although he is a habitual delinquent, the court cannot anymore punish him for vagrancy because of the principle of nullum crimen nulla pena sine lege. Express provision. Congress, in passing a law, can insert a provision on retroactivity subject to the constitutional prohibition of ex post facto law. If the law expressly provides retroactivity, the court must give retroactive effect to this law, even if the accused is a habitual delinquent. If a child in conflict who is a habitual delinquent committed a crime prior to RA number 9344, he is entitled to retroactive application thereof. Section 68 of RA 9344 expressly provides retroactive application of the privileges to a child in conflict with the law without condition. On the other hand, Article 222 of the Revised Penal Code provides retroactive application of the favorable law subject to the condition of non-habitual delinquency. Since Section 68 of RA number 9344 is a specific provision while Article 22 of the Revised Penal Code is a general provision, the latter yields to the former. Generalia specialibus non derogant. Hence, the retroactive effect of RA number 9344 is unconditional. In Hernan versus Honorable Sandigan Bayan, GR number 217874, December 5, 2017, accused was convicted of malversation under Article 217 of the Revised Penal Code, involving the amount of 11,300 and sentenced to suffer a penalty of 11 years, 6 months, and 21 days of prison mayor. The judgment becomes final prior to the effectivity of RA number 10951 under Article 217 of the Code as amended by RA number 10951. The penalty for malversation involving an amount not exceeding 40,000 is only prison correctional in its medium and maximum periods. According to the Supreme Court, the general rule is that a judgment that has acquired finality becomes immutable and unalterable and may no longer be modified in any respect, even if the modification is meant to correct erroneous conclusion of fact or law. This rule is applicable whether the final judgment was rendered by the lower court or the highest court of the land. However, when exceptional circumstances exist, such as the passage of RA number 10951 imposing penalties more lenient and favorable to the accused, the court shall not hesitate to direct the reopening of a final and immutable judgment, the objective of which is to correct not so much the findings of guilt but the applicable penalties to be imposed. Because of RA number 10951, sentence of the accused must be modified respecting the settled rule on the retroactive effectivity of favorable laws. Thus, the Supreme Court reduced the penalty to 3 years, 6 months, and 20 days of prison correctional. Section 101 of RA number 10951 provides, "This act shall have retroactive effect to the extent that it is favorable to the accused or person serving sentence by final judgment." This provision does not require non-habitual delinquency as a condition for the retroactive application of the favorable parts of RA number 10951. Thus, even if an offender who committed malversation prior to RA number 10951 is a habitual delinquent, this law shall be given retroactive effect as far as the penalty under it is favorable to the accused. Article 22 of the Revised Penal Code on the requirement of non-habitual delinquency for the retroactive application of a favorable law is not applicable. Effects of repeal. There are two kinds of repeal of criminal law, to wit, absolute repeal and partial repeal. Absolute repeal of a penal law deprives the court of jurisdiction to punish person charged with a violation of the old penal law prior to its repeal. In People versus Tomayo, GR number 41423, March 19, 1935, the accused had appealed from a judgment convicting them of a violation of a municipal ordinance, and while their appeal was pending, the ordinance was repealed, such that the act complained of ceased to be a criminal act but became legal. The case shall be dismissed. The intention of the new law in totally repealing the old law is to decriminalize the act punishable under the latter. In sum, under the present law, the subject act is not anymore a crime. Hence, a person should not be punished for committing a non-criminal act, applying the principle of nullum crimen nulla poena sine lege. Moreover, the present law decriminalizing an act is favorable to the accused. Hence, it should be given a retroactive effect without precondition. Lifted in 2011 bar exam. The retroactive effect of the decriminalizing law shall benefit a person who is already convicted or serving sentence. In sum, he shall be relieved of the penalty imposed upon him for committing a crime under the old law, which has been decriminalized by the present law. The accused was charged with violation of Section 1458 of the Revised Administrative Code. Therefore, thereafter, Tax Code repealed the Revised Administrative Code but did not reenact the provision penalizing the acts of which the accused is charged. This is an absolute repeal. The accused should be acquitted. Where the repealing law failed to wholly penalize the acts which constituted the crime under the repealed law, the repeal deprives the court of jurisdiction to punish persons charged with a violation of the latter. Partial repeal. Repeal with reenactment of a penal law does not deprive the court of jurisdiction to punish persons charged with a violation of the old penal law prior to its repeal. Such repeal, even without a saving clause, will not destroy criminal liability of the accused. The intention of the new law is not to decriminalize an act punishable under the old law, but merely to provide new rule. If the new law is favorable to the accused, who is not a habitual delinquent, it shall be given retroactive effect. A was charged for the crime of rape under Article 336 of the Revised Penal Code for raping his minor daughter. However, RA 8353 expressly repealed Article 336 of the Code but reenacted the provision on rape by inserting Article 266A and B in the Code, which now punishes rape with a graver penalty. The repeal of Article 336 does not deprive the courts of jurisdiction to try and punish A for rape under Article 336. RA 8553, RA 8353 shall not be given retroactive effect since it is not favorable to the accused. If convicted, the penalty under Article 336 and not under 226A shall be imposed upon the accused. Section 45 of RA number 10591 has expressly repealed Section 1 and 2 of PD number 1866 on illegal possession of unlicensed firearm. However, the former has reenacted this crime by punishing illegal possession of loose firearm under Section 28 thereof. Effects of amendment. Amendment of penal law shall be given a prospective effect, but if the amendatory law is favorable to the accused, who is not a habitual delinquent, the same shall be given a retroactive effect. Okay.